Cecily, here to talk about the Employment Rights Act.
We are indeed. Hot topic.
Yes, the most significant change to employment rights in a generation, at least.
Indeed.
So we're told. We've been listening to all the commentary, talking about it since the early days of the new Labour government, formed part of the 100 Days plan. And if I'm not much mistaken, it was introduced as an early Christmas present.
It was indeed. It does feel like it's been a long time coming, hasn't it? We've been talking about what was the Employment Rights Bill for about 12 to 18 months. And then just before Christmas, we had the festive delight of the bill receiving royal assent on the 18th of December. And since then, we've now got the exciting Employment Rights Act 2025.
We have. And the most talked about parts of it are clearly the changes to unfair dismissal, but there are some significant changes coming in ahead of that. And we know that it's not all about unfair dismissal. There are actually 50 changes that employers need to get on top of. And the very earliest are coming in on the 18th of February.
They are indeed.
Followed hot on the heels, and we've got April the 5th and April the 6th are some rather significant changes which are perhaps not talked about as much. So this morning we want to have a run through of the changes that are coming in April, but perhaps before then it's an opportunity for us to reassure employers and businesses generally that yes, we've got 50 changes coming in, but if you start planning now, if you start talking to us now, we can support you through the changes.
Yes, absolutely. Change is always a time of uncertainty for businesses, and with the number and extent of the changes coming in, there isn't really an area of HR and people and staff management that isn't being impacted or changed as a result of the change in legislation. And what also doesn't help is, whilst the Employment Rights Act now finally here is great, it's more of an overarching framework. It's the first in a series of legislation that's coming in. So whilst we have a lot of the detail that we didn't previously have, there's still so much more to come. So focusing today on the April changes is one thing, but it's about having that weather eye on the horizon to see what else is coming in both later this year, in 2027 and beyond, as and when further secondary legislation is published. So it's going to be a busy time, and we're very much here to help all organisations in getting ready for the changes. We were very pleased to announce that just before Christmas we've launched our HCR Employment Rights Act Hub, which we're hoping to be a fantastic resource for businesses to use. On there, it's got roadmaps, it's got flowcharts outlining what changes are coming in and when. We've got thought leadership pieces from a number of our internal champions across the employment team here at HCR, talking at high level, but also in detail about the changes as we know them now. And what we'd like it to be is a really great one-stop shop resource for employers and HR managers and those within those spheres in the business world to have an insight into what's coming, the practical steps that they can be taking now and in the future, and how to get buy-in as well from the wider business, as well as then dealing with the individual changes when staff come to them with the inevitable queries that are likely to arise now and in the future as well. So it's definitely a fantastic resource that we will continue to update as changes are announced as well. So thoroughly recommend everybody checks that out.
Yeah, because that's what it's all about, isn't it, ultimately? I mean, we, as employment lawyers, we get very excited about the detail and the fact that when the bill was first published, it ran to 100 pages. And then when it was finally enacted, we've got 300 pages to grapple with. Yeah. But ultimately, the important part about the Act is what's the impact on your day-to-day employee relations and what's going to happen in relation to people who want to take family leave or people who are being consulted with about changing their role. So, for I think businesses and employers generally to know, well, where can I go and get some help? And I think my approach to it is going to be let's bite it off in small chunks,
yes,
rather than be overwhelmed about 50 changes coming in. Let's walk through what do you need to be ready for and when.
Yeah, and there's different levels of change and preparation that businesses will need to have. So some changes might just be payroll awareness or updating one policy and then sending that live, whereas others will be a complete change in shift of how you manage staff through a particular issue or how to respond to something, which will just require further thought at an earlier stage. So we're helping organisations with that. So when they need to prepare, what for, and when in advance, they've got plenty of time to navigate that.
And I mean, as we say, we've got a little bit of time to get ready for some of the bigger numbers, and really, I suppose I'm regarding this as a bit of a limbering up phase.
Yes.
And with employment law, we're used to lots of change happening, and it used to be that we were always ready for the April changes and the October changes every year. As well as, you know, all the stuff coming in from the left field all the time by way of case law developing all the time. But we know, you know, we've got to be really match ready for the stuff that's coming up in 2026 and 2027.
Absolutely. You cannot be over prepared for these changes, and forewarned is definitely forearmed, and the organisation, whatever size, whatever resource, will just be so much better able to show that they're leading from the front, that they are agile and reactive to these changes, but also it then means that as and when staff queries arise, they've got the resources internally for managers and leaders within the business to deal with, but also that the HR teams will be familiar with what to do and when. So we really can't emphasise enough the need to be preparing now and sooner rather than later.
Yeah. So it's very much all about the preparation, and businesses that have got a cycle of what do we need to think about this year that have always been used to working to a plan of what's coming in for the new financial year. They're going to adapt much better than those who don't necessarily know about changes coming in. So I suppose, I mean, this is a good time to start talking about a little bit of the detail, and if we move into what we're expecting to see at the beginning of April, shall we just talk through what those key changes are? And although I think, as I said, the unfair dismissal changes, the big ticket items have garnered most of the news, there are some other significant changes that are happening, and 7 key ones for the beginning of April 2026. So shall we kick off with what we're going to see in terms of family rights?
Yes, absolutely. So we're going to see a number of changes to family-friendly leave entitlements, and many people will be familiar with the existing rights. They've been around for many, many years, but there's almost a sort of harmonisation piece where a number of the changes are bringing in those rights to more members of staff at an earlier stage. So there's a number of changes that are now going to become day one rights for more members of staff from the 6th of April onwards. So particularly we're looking at unpaid parental leave.
And remind ourselves about which one is that one?
Absolutely. So unpaid parental leave is the ability where an employee can take up to 18 weeks leave per child up to their 18th birthday, and that's capped in blocks of a week. You can't just take a day here or there, and you can only take up to 4 weeks maximum a year. Now, HR will be familiar with it already. I'm sure they'll have policies and procedures in place for it, but we typically find that it's not the most common right that's used, particularly when organisations don't have to offer pay for it. The statutory basis is that it's unpaid. Some organisations do enhance that and do offer pay, but because of that, it's often frequently only used, if so, by those that are able to do so on higher salaries, for example, where they might need flexibility for childcare around half terms and things like that. So at the moment, a member of staff would need to have 1 year's service in order to take that right, and that's being brought down to be a day one right. So it's something that employers should already be familiar with. It just might be that there's staff that are asking for it earlier than they might otherwise have been entitled to it.
Okay, all right. So is there anything else on the family-friendly front?
Yes, indeed. So we've got paternity leave. That's also becoming a day one right. So at the moment, a member of staff would need 26 weeks service in order to then request and notify their employer that they're going to take it. And that's being brought down to be a day one right as well, to match things like the existing benefits to maternity leave and adoption leave and so on. So there's a sort of alignment piece there, which makes a lot of sense behind the intention behind the changes in it. There's also some changes where, at the moment, if anybody's navigated the thorny leave issues of shared parental leave, which came in 2015, where the mother can curtail her maternity leave, and it almost goes back into a pot that the partnership can choose between themselves how they then take that leave and pay and share it. there were some, unfortunately, quite complex rules that meant that paternity leave had to be taken first before then the member opted into the shared parental leave scheme, and that's now being changed. So there's greater flexibility such that somebody could take shared parental leave first and then take paternity leave if they wanted to do so. So not hugely significant in terms of a entirely new right of leave or, substantially different in terms of the cost to the business. It's just bringing the accessibility to be able to take that right earlier into organisations so that staff can take it from day one if they wish.
Great. And then there's, just for completeness, there's another family leave related, although not strictly part of the Employment Rights Act.
No, but for completeness, I think it does make sense to cover it at this point. So we're going to have a bereaved partner's paternity leave legislation brought in, and as you say, it falls outside the Employment Rights Act. This isn't to be confused with stillbirth bereavement leave that's coming in under the Employment Rights Act later on next year, but this will be a new piece of legislation where there will be a new right for staff to take time off where the mother or primary adopter of a child dies within the first 12 months of a child being born, reflecting what a lot of organisations already do in terms of additional or voluntary compassionate or bereavement leave, but it does bring a new legislative basis for that to be taken for staff to do. So some sort of more subtle changes, I think we can say, not sort of significant, not a entirely new sort of right, apart from the bereaved partner's paternity leave legislation, but it's a case of having a look at where your handbook and policies are on these entitlements at the moment, making sure that they're up to date generally, but up to date and ready for these 6th of April changes, making sure that managers and those that are leaders in the business are aware of the changes so that if staff come to them with queries, they're signposting them to the right policies, there are people in HR that can answer those questions. But I also think it's a good time for organisations to consider what they are offering in terms of leave and the enhancements, if any, that they can afford to do for pay. And it might be that they look at enhancing some of these bereaved leave or unpaid parental leave provisions. It might be that they want to take the opportunity to offer, if not a small amount, but an additional amount that's on top of the bare minimums that currently need to be offered or will be from the changes in the 6th of April. So keeping things under review, updating your policies and procedures, ensuring there's awareness internally, but also using it as a bit of an opportunity to review what do we do and what would we like to do now that these changes are coming in.
And it makes sense when you're thinking about recruitment and the sorts of benefits that as an organisation you want to offer to your employees. So the next one that I thought we'd just very briefly touch on, because it's very much the hallmark of the sorts of changes that the Labour government is wanting to bring in. There is one of the elements to changing engagement with trade unions. We've got some coming in February, and then we've got another one coming in April.
Yes, and this is part of a wider sort of direction of travel where there's, I think, at every tranche or milestone change point that's coming in under the Employment Rights Act and subsequent legislation, there's always a trade union element to each part of the change. So yes, from the 6th of April, we're going to have a simplification of the trade union recognition process. Now, without wanting to get too much into the thorny details of it, there are mechanisms by which trade unions can seek to be formally recognised, either on a voluntary or formal basis by organisations. And put simply, it's just quite an onerous and quite challenging process for unions to go through to do that. And the incentive and the intention behind these changes is to just make that easier. So there will be a simplification of that recognition process coming in part in April, with then further changes how unions can access workforces and the information that employers are required to provide to staff coming in later this year. So we are aware and we are seeing, in terms of sort of wider commentary, that the unions are obviously very keen to get access to workforces. And I think typically there can be a little bit of a mindset piece where organisations that haven't been either impacted or used to dealing with unions in the past just sort of think, oh, well, we don't deal with unions, we don't recognise it, we don't need to worry so much about these changes. But do be aware that these changes are about allowing further access to these organisations by unions. And we're aware that some unions are already collating lists of employers that they want to target and approach. So the unions are getting prepared, and they've been ready now for some time and in readiness to go into organisations and so on. So just because your organisation may not have dealt with unions to date doesn't mean that you won't be moving forward. So definitely a sea change for some organisations on this awareness point. So yeah, it's that there's also in some of the future changes very tight timescales for when things are to be coming in. So be aware of it. It's not so significant for the 6th of April changes, but definitely something to keep an eye on, because it is the direction of travel where things are coming in for later in the year as well. So definitely something to be aware of.
And I always think, I mean, if there is something that might be coming to visit you on the trade union shape, that it's always better to be ahead of that and be thinking about how would I engage with this positively, rather than being on the receiving end. What would I want that to look like? And I think if you've got a bit more agency about what your relationship with a union would be like, it's a much better place to be in than having a recognition agreement imposed on you where the union is dictating the colour of the toilet paper, for example. So, yeah, I mean, it's just a good reminder again, isn't it, of where we want to go with this. And then I suppose the other one is a fairly significant change in terms of, I mean, it's relevant to unions again, but when we're talking about collective consultation and collective redundancy, what's the big number change that we need to think about there?
Yes, people might be aware things are going from 90 days to 180 days. That's the sort of headline in terms of the numbers, but what does that mean? So at the moment, if an organisation gets it wrong, to oversimplify it, but where there's a duty to collectively consult in relation to redundancies and they either fail to do so or they get it wrong in how they're doing it, at the moment, tribunals can award 90 days uncapped pay per employee where there's been a failure to collectively consult. That protective award is increasing from that 90-day to 180 days. So obviously an employer does not go into a collective consultation seeking to do it wrong unless things are so severe that they're looking to not engage at all, which is a different issue which we won't cover today. But it's a quite significant change that the penalty is doubling, and there is a risk that mistakes can happen, things can be overlooked. Going into a redundancy consultation is not something that a business takes lightly. It is an issue, it's when they're facing particular challenges, and they need to be aware of not only how to do it and how to do it properly, which of course was the case at the moment and before, but the cost of getting it wrong is not only going to be more, but it's doubled from what it was.
And I mean, it's salutary, isn't it? Because it's triggered if there are 20 or more people affected. So the prospect of having to pay 6 months' pay for 20 employees where you've got this wrong is pretty horrific. And in many cases, people are going into a redundancy exercise because there's a pressure on costs. So another one. And then we've got something related to sexual harassment as well, haven't we, coming in?
We do indeed. And similarly with a lot of these changes, this is one of a number of changes coming in, with the later changes happening with more significance in October as well. But at the moment, from the 6th of April, reporting an allegation or concern of sexual harassment will form a standalone basis of being a qualifying disclosure under whistleblowing protection. Now, there's a lot of discussion internally and with employment lawyers and employment law commentators that this isn't really going to change anything significant, because at the moment, the number of grounds on which you can bring a whistleblowing complaint do include a breach of legal obligations or unlawful conduct, and arguably sexual harassment would very much fall within that. But it is about making sure that it's transparent and clear, so that if somebody is making an allegation, one of which or all of which include allegations of sexual harassment, that is very clearly now, albeit I don't personally think there was much doubt before, but it will absolutely be the case now that that is making a protected disclosure and will be protected under the whistleblowing legislation.
Okay, good to know. And then I suppose moving from one where we don't think it's a significant change to something where it's a very significant change, particularly for people on lower pay.
Yes, so we've got a change coming in, again, 6th of April, about changes to statutory sick pay. So at the moment, if somebody reports and is off sick, there is what's known as the 3-day waiting period before statutory sick pay entitlement kicks in. And that 3-day waiting period will be removed. So statutory sick pay will be payable from day one. Now, many organisations that seek to enhance sick pay do that already, and it's almost where they start with the enhanced sick pay and then the statutory sick pay kicks in to support that from underneath later on. So many organisations may not see that necessarily as a significant change, but lots of organisations don't offer enhanced statutory sick pay. And knowing that it is payable from an earlier date, so day one of the absence, is going to be quite significant. practically in terms of reporting and managing that sickness absence, but obviously the cost of paying that too. Now, it's not just the timescales that have been shortened and crept forward. We've also got the removal of the lower earnings limit, so it's one of the eligibility factors. So workers earning less than that will now be entitled to 80% of their weekly earnings as part of SSP. So not only have we got SSP being paid earlier and arguably therefore potentially for longer, but to a wider section of the workforce, including those that may previously not have been entitled to it. So quite a significant one for employers.
Okay, great. And I mean, another one I suppose that feels a little bit ineffable is the action plans.
Yes, absolutely. This is one of those that's a bit of a grey area. Now, whilst we're quite short on time ahead of the changes coming in from the 6th of April, this is a voluntary process at the moment. So what the government would like to do is to encourage employers with 250 staff or more to engage on a voluntary basis on publishing both gender equality plans and also menopause action plans. Now, I say at the moment, it's important to be clear that these are voluntary publications from April, and later in this year, or if not next year, it's going to be that it's mandatory to do so. But we're in a little bit of a quandary where the government is saying that they will issue further guidance on what to include in these, at the moment, shortly to be voluntary, later mandatory action plans that they need to report. But it's great that they want to encourage transparency and publication of these things earlier, but without setting out guidance for what organisations should or must be covering, it's just a little bit vague at this stage. So something absolutely that organisations, if they want to be sort of bold and forward and looking to publish that information and assess what they're doing, but with the absence of the information that's going to be quite key as to what to include, yes, it's on a voluntary basis at the moment, but it might just be worth, if organisations are keen to take part in this, to actually looking at doing it internally and working out what they do and when and what it shows before making that decision. And again, getting prepared and looking at it now whilst it's voluntary is great before you then might be forced to do it later on. But yeah, we've got an absolute absence of clarity really at this stage what that's going to involve.
Okay. And finally, in terms of the key changes coming in April, we're going to be welcoming the Fair Work Agency.
We are indeed. So if the 6th of April wasn't exciting enough in your calendar, on the 7th of April, the Fair Work Agency will be established. Now, we've got indications at the moment that this will be an enforcement mechanism, a sort of naming and shaming, a one-stop shop, which will collate a number of existing threads and arms across government. But it's seeking to provide guidance to businesses, but mainly act as the sort of stick to force compliance, looking at enforcement, looking at bringing organisations to account where they may have failed to do something, either innocently or intentionally. But it's to look at taking on that enforcement piece of some of the wider employment rights. So we've got examples of things like holiday pay, sick pay, national minimum wage enforcement, but there's also been discussions that they will be able to bring claims on behalf of workers as well, which is it's quite a powerful right and isn't something that exists in any other organisation at the moment. So we have to wait and see what the detail is, and hopefully, and they announced sort of October, November last year that Matthew Taylor will be the chair of the Fair Work Agency. So I imagine behind the scenes, everybody's sort of scurrying around and working out what it is that it will do come 7th of April. But at the moment, we don't yet know the extent of the teeth, want of a better phrase, of what it will have. We don't know the sort of funding, the resourcing, the size, the staffing. We can guess and make sort of a number of assumptions that it might be that they want to go after particularly large organisations, maybe to make a point, maybe to sort of scaremonger a little bit and ensure there's enforcement and compliance. But I think it will also form part of a wider picture where there can be naming and shaming and publishing lists of things. So hopefully it'll be both. It'll be a mechanism of enforcement, but also a resource to provide guidance and to ensure that organisations get things right from the outset. But we'll just have to wait and see on more detail as to what it's going to do and how powerful it's going to be.
And I mean, obviously Matthew Taylor's a name that we've heard before, talking about employment rights, and he produced the report in 2019 in relation to improving the landscape in employment law, and you know, we can only hope that we're going to see some improvements. I suppose what we're hearing about the ability of the Fair Work Agency to bring employment tribunal claims on behalf of individuals, should we feel at all optimistic that this will improve the sorts of delays that people are experiencing at the moment in employment tribunal claims?
Personally, I think not. I'm afraid the employment tribunals is unfortunately quite under-resourced sector. We're seeing significant delays. It does depend on the region, but hearings are getting pushed back months, if not years, after claims been issued. That can often be very challenging for people to be able to get in touch and find out more. And we've had the joys of the portal being launched and engaging with things electronically, and the digitalisation piece is fantastic and very important. But when it works well, and we're still dealing with teething issues since it was rolled out in May last year. So I think, unfortunately, whilst an additional body that can bring claims sounds fantastic, I think a lot of the reality will come down to it being an additional burden on a resource that's already struggling with the amount of claims that are currently going through. So fingers crossed we may see some wider reforms as part of all these changes to come in and support the existing systems in place. But at the moment, there isn't any standalone additional support being offered for these already stretched systems.
Okay, well that's, I think, I mean, we can only continue to be optimistic in the face of experience, which hasn't been fantastic. And what we know about the other changes coming in beyond this April is that they too are likely to bring additional pressures for employers generally and the employment tribunal system. Because, as one example only, we know that people are going to have up to 6 months now to bring unfair dismissal claims rather than 3 months, as it is at the moment. And come 2027, we'll be seeing those other significant changes to unfair dismissal rights, where at the moment people have to wait for 2 years to qualify for those sorts of claims if they're dismissed. But we're going to see it's 6 months as from January 2027. Yeah. And we're also seeing a removal of the cap on compensation.
A last-minute entry into the legislative changes that was a bit of a surprise to all of us. Yes, absolutely. So, yeah, the changes coming in April, I think, are of less practical significance, but more the sort of flavour of change that employers really need to be getting their heads around. We've got quite significant changes coming in October, in addition to the harassment changes, reintroduction of third-party protections, but also to take all reasonable steps. And don't want to just spoiler alert, there will be future videos discussing these future changes and getting you ready for those to come. But this is part of a sea change in the protections and rights that individuals will have, and unfortunately some of the red tape that employers are just going to have to navigate. So getting prepared for these changes now, obviously critical, clearly very important, but it's having that mindset to be able to deal with the additional, more onerous, more extensive changes that are coming in October, 1st of January, and wider through 2027. With some changes, we don't yet know when they are going to come in. So it is really to these further changes and subsequent changes that people are going to need to be getting used to. I think there's a lot of the practical bits that we are covering in videos like this, but also on our hub as well. So as and when we know more, we're very much publishing that information. But April is one thing. It's getting ready for the future, the rest of 2026 and onwards into 2027 as well.
I mean, just in terms of employers thinking through, this is how I navigate the next 2 years and beyond of those sorts of changes. And, you know, like any business, we've got limited resources to be able to plan for all of these changes. So I think if the beleaguered HR manager is sitting and thinking, well, what should I do now? What's the best use of the time that I've got to make some plans and be a little bit ahead of that? What would we be saying to, we assume it's a she, to her about what are some key steps that she could take at this point in relation to contracts, policies, just that kind of getting ready?
Yeah, I see an overarching theme of a sort of two-pronged approach. I'm talking about awareness and accessibility. And within that then comes the detail of the changes, as you say, the practicalities. So at this stage, you really want to be making sure that your HR team around you are aware of the changes, that they have an eye on the milestones as they're coming in, so they've got that awareness information as well. You might wish to have a select group or a subcommittee within your HR team that are leading on the Employment Rights Act changes. Really think that would be a great resource to put in place. It can also help with engagement with the wider workforce and or senior leadership teams and the board. You might be wanting to put together board reports and If you need additional funding, which we'd strongly recommend that HR teams are able to secure for this year and the next, it's demonstrating why that is needed, given the extent of changes and support. And if you are able to reach out to us or your chosen law firm as a trusted advisor, having that additional resource there can be critical at this to help navigate not only the thorny legal issues, but the practical challenges as they come through as well. So definitely at this point, be aware of what policies and procedures you have, where they are, what sort of shape they're in. Things change all the time, and we appreciate that some things can get out of date quite quickly. There is no blame, shame or criticism for that at all. The landscape moves very quickly and will now unfortunately continue to do so. So it might be that you have a system where you have policies either in a whole handbook and you're looking to sort of take them out and have them as individual policies on your intranet. Absolutely great, but make sure that they are reviewed regularly, that they're kept under review, that they're updated as and when things need to be changed in them, but also having that wider discussion piece so the leadership team know what's happening and when. That can be a top-down led approach. The attitude, the mindset to change inspires those in management and sort of more middle roles so that when they're facing the queries coming up from staff underneath, they know what the resources are available. It's not the case that we often had. So, for example, when shared parental leave came in and staff were making requests to their managers to take it, some managers were going, well, no, you can't have this time off. And unfortunately, that wasn't the correct answer. So training internally, being able to ensure that even if they don't know the answer, they've got the signposting to come back to policies or to HR. Definitely ahead of changes next year, you've been wanting to look at your recruitment changes this summer, because the staff you'll be taking on this year will be staff that you will, in all likelihood, have next year when the changes to unfair dismissal are coming in. So people are getting quite concerned about probationary periods. Yes, a great contractual mechanism, but are not dependent on the changes to qualifying service that are coming in. So awareness of what you do, which may seem obvious, but often in large organisations that gets a little bit lost. Consistency, accessibility to these documents, keeping them up to date, having a trusted expert team around you to be able to support, but also internally to be able to react and act quickly with these things. So it's a bit like, and I bring all analogies back to food because it's the best thing, but making sure that you're preparing for the feast that will continue to change ahead and not just getting the shopping list organised, but getting the chefs in the right place in the kitchen at the right time to be able to help take you forward on that. So yeah, an eye on the horizon for now, but also for later as well.
Okay, sounds like good advice. And I suppose just to stick with the food analogy, for me, if there was just one dish, it would be looking at people's probation periods, because if you've got the standard sort of employment contract that gives everybody a 6-month probation period, and by default, that's what your managers expect to do, then you may well find yourself coming a cropper with finding that someone you've dismissed because they're not particularly brilliant at the end of their probation period, they can now qualify for a claim of unfair dismissal. So I think that would be a dish that you ate at your peril, and one that we would just encourage people to stop and just make that little tweak to process and contract, and could be really, really useful.
Absolutely. I think my chosen dish at this point as well would be the fire and rehire changes ban. It's a bit of a draconian method, but is often used at the moment where you're looking to effect changes to terms and conditions and staff may not agree. And then almost as a last resort, you have the ability to seek to fairly dismiss and offer re-engagement on the changed terms that you were trying to get through. Now, there are statutory codes of practice and obviously fair processes and so on that you have to follow now, but the changes under the Employment Rights Act are going to, from 2027, look to make that very, very challenging to do, if at all. There's going to be very limited exceptions where that can happen. And I think often organisations don't know what they want to change and then suddenly know what they want to change and then want to work out how to navigate that. It's just going to be so much harder to make any changes to existing workforce rights, particularly the obvious core ones like pay and working time and so on. So just having that weather eye on the horizon, that if you know that the organisation might want to make changes, you might not be able to make them, if at all, let alone very easily, coming up in the later this year and early next year. So having that eye on the horizon now, and if you need to, trying to make changes now, albeit that obviously it's not as easy now anyway. So just, yeah, that would be my other hot dish as well that people should be looking at this stage.
Okay. We would implore people again to have a look at the array of resources and useful stuff on the HCR Employment Rights Act hub.
Absolutely. It's not just a legal resource. We don't do dry, boring legal advice here at HCR. We very much look at the practical impact as well and helping people get ready and navigate this journey. So we will be keeping it up to date as well as we find out further information. But yeah, absolutely implore everybody to visit that as the initial resource and get further information from there. We're also offering sort of surgery offerings, either bespoke or fixed fee. We've got training resources that people are able to purchase and look at as well. And we offer tailor-made solutions to all organisations of any size as well. So we really can make that support fit for the organisation as well. So definitely look at the free resources we've got at the moment. Definitely don't hesitate to get in touch if you've got any queries, and then we'd be delighted to help organisations navigate this moving forward.
Great. Thank you.
Thank you very much.